Right, welcome everyone. We'll make a start. So welcome to this Renting Homes Wales webinar. Lovely to have you here. I'm Jackie Leonard. I'm the Head of Projects Wales for CHIC. We have two excellent speakers with us from Devonshire, and they're a law firm that are currently working with a number of social housing providers on this. So it'd be really good to hear from them. We've got Victoria Smith and we've got Julian Barker. Just wanted to say they're going to do their presentations, and after that we'll have about 15 minutes for Q&As. So if you could put any of your questions in the Q&A box at the bottom of Zoom, that would be great. What we're going to do is obviously afterwards circulate the presentation and link, and if there are any questions that we don't get round to, we'll put that in our communication back to you at the end. So that's great. So without further ado, I'm going to pass on to Victoria and Julian for their presentation.
Great. Thanks, Jackie. Hi, everyone. Thank you all for joining us today. As Jackie has mentioned, I am a solicitor in the housing management team here at Devonshire, and I have been assisting landlords primarily at this time with preparing for implementation of the Act. And I'm going to be looking at some of the key changes being introduced by the Act, and also some of the terminology, because as we know, there's been a lot of changes. What they've said is that, the biggest change in decades to housing law in Wales. So we just need to be prepared for implementation and making sure all the steps are in place and ready for implementation on the 1st of December. Next slide, please. Thank you. And again, sorry, a couple more slides. Thank you. And excellent. Yeah, great, lovely, thank you. So firstly, I'm just going to be giving you a bit of an overview of the Act. So it was introduced with the idea of simplifying residential tenancies and the regulatory framework in Wales. I think at this stage it is going to be difficult to say whether that will simplify the process. There are a lot of changes, but I think as the Act comes in and as we start using them, we'll be able to look at that further. The Act received royal assent in January 2016, so quite a long time ago. There has been some changes, and as we see with regulation, that's ongoing even this week, or the end of next week, there was further changes. And then the delay likely due to, or the more recent delay likely due to COVID, and also some issues with banking, which Julian is going to be talking about later. So the Act is currently set to be implemented on the 1st of December. I say originally due on the 15th of July, but there was that extension. But it's unlikely now that there's going to be a further extension, so landlords should be making sure that everything is in place before the 1st of December this year. Next slide, please. Terminology. So the Act basically changes the whole of the tenancy regime in Wales as we know it. There's some new terminology that I'm sure a lot of you have got to grips with already. I'm just going to talk you through that. So the first is landlords. So what we'll have now is we'll have community landlords. So they are primarily local authorities and registered social landlords, so most likely everybody on this call. We've then got private landlords. So they are your any other landlords, so landlords in the private rented sector. The tenants and licensees are now going to be called contract holders. There are some limited exceptions, and tenancies and licenses will no longer be tenancies or licenses, other than I say with some limited exceptions. For example, holiday lets, temporary accommodation. And what they'll now be from the 1st of December, they will automatically convert to what they'll call occupation contracts. Okay. So there's going to be two types of occupation contracts. The first contract is your secure contract. So they will primarily be granted by community landlords, so your RSLs, local authorities. And then your second type is your standard contract, which will be granted primarily by private landlords. Now, there are some limited exceptions. Community landlords can grant standard contracts, for example, where there is supported housing. So you'll have a supported standard occupation contract, be it fixed term or periodic. And then they can also grant introductory standard contracts. So like your introductory assured tenancies that we see now. Each contract will have a written statement. So that is basically a term for tenancy. So it just has all the terms set out. And they will be set out in some model contracts. So the Welsh Government has produced a number of model contracts. They've produced a secure contract, a standard periodic and fixed term. They haven't created model contracts for supported accommodation, for example, but there is some guidance on the Welsh Government website of how to create those contracts. Another thing to note on model contracts is proceed with warning, because there are a lot of terms that we would usually see in a tenancy agreement missing from those contracts. So it's just really important that when you're carrying out the process of drafting the contracts, don't just take the model contract from the Welsh Government website. There are, as I say, a number of things that need to be added, and I'll be going through those in a moment. So just make sure you're carrying out a full review before you grant those contracts. Okay, next slide, please. The model contracts and occupation contracts generally. The contracts will have 4 terms. So I'm going to go through those now. So the first term is your key matters. So these are near the beginning of the contract, and they set out things like your party's details, the property address, the rental charges. Your next type of term is your fundamental term, and these can be split into 2 categories. The first you'll see in your contracts is marked with an F, and those fundamental terms are possibly the most important terms. They cannot be modified or removed. They must be in the contract. So you take them, as I say, from the government's model contracts. An example of that is a requirement to use the tenancy deposit scheme if you're taking a deposit. And another example is that the contract holder is not to engage in any nuisance or annoyance. What's really interesting here is, as we would usually see in a tenancy agreement, there would be a term in relation to nuisance and annoyance, but there would also be a term in relation to violence or harassment, for example. And that term is not a fundamental term in the contract. So what we would be suggesting is that you add a term like that as an additional term. The other type of fundamental term is a F+, and they, as I say, are marked in the model contracts under F+, and they can be modified or removed, but only where it's agreed between the parties and it improves the position of the contract holder. Okay. An example of that is that the landlord has a right to enter the property to carry out repairs. And another example is that the landlord has an obligation to keep the property in repair and fit for human habitation. Now, fit for human habitation, I'm going to be talking about that a little bit later, but that is a new obligation being introduced in Wales. It's important that that is noted and action is taken to ensure properties are fit. Okay. Next slide, please. The next type of term is a supplementary term, and these terms are set out in regulation. So they should be included, they will be included in the model contract, but they can be removed or modified, but only if it's agreed between the parties and it doesn't conflict with a fundamental term. Now, there's a number of these set out in the model contracts, which I would suggest slightly amending. For example, there is a term in there which is set out in regulation, and it's that the tenant, or the contract holder, is not required to pay rent for any period that the property is fit for human habitation. And I think if a tenant sees that, they're likely to maybe withhold rent, stop paying if they think that the property is unfit, and that could result in significant rent arrears, and there's been no determination. So I would suggest amending that clause slightly to make reference to not required to pay rent for any period the property is unfit, if agreed in writing by the landlord or a determination is made by the court. Another example of a supplementary term is that the contract holder is not to carry out any trade or business. And there are many other ones, so it's just important to review those, make sure you're happy with them, and if you want to make any amendments, ensure they don't conflict with fundamental terms and get agreement with the contract holder. And then finally, additional terms. So additional terms, the government has said, is any other terms that can be agreed between the parties. They give an example of keeping pets at the property, but actually if you take a look at the model contracts, firstly, they don't include any additional terms. So it's really important that you're looking at your current tenancy agreement and any other terms which are not in those model contracts, making sure that they're transferred over and added. So, for example, which I think, although they say, they give an example of pets, there are much more important clauses you would want in there. For example, the requirement to pay rent and service charge at a certain time, so rent each week, for example. There's the ability to take possession by abandonment. There's no note of that. And as I've said before, there's no prohibition on harassment, violence, things like that. So it's really important that those clauses are added, because then if you were to look to take possession, you could rely on a breach of tenancy or occupation contract. Great, next slide please. Now, an occupation contract must be issued to a contract holder. For any new occupation contract granted from the 1st of December, the contract must be issued within 14 days of occupation. And for a converted occupation contract, so that's your tenancy or license now, which converts into an occupation contract, whilst it will automatically convert on the date of implementation, so that's the 1st of December, landlords have 6 months to issue written statements. So you've got until June 2023. Now, if the landlord fails to issue a written statement, then the contract holder can seek compensation. If the default is intentional, then the contract holder can apply for an increase in that compensation as well. And then finally, if the contract is deemed incomplete, I think mostly reference to converted contracts here, compensation could be payable, but only where that is because of an intentional default from by the landlord. So, I think it's going to be rare that there would be an intentional default, especially with RSLs, for example. But I think it's important here to note that you just make sure you're making note of the procedure of drafting those contracts so you can show your workings out and that there was no intentional default. Okay, next slide, please. So, converted contracts. So when you've got a new contract, so from the 1st of December, as I say, you can use the model contract by the Welsh Government, albeit make sure that you're looking to amend those adding clauses. But for any tenancy or license in place now, the procedure is a little different. So what you need to do is carry out a conversion process. And I'm sure a lot of you are well underway with this process now. And what that basically is you're taking terms from the model contract, but you're also taking terms from your current tenancy. It's going to be quite a big job because, as I'm sure a lot of you have tenancies which have changed over the years. So you just need to make sure that you're looking at those individually and issuing the correct contracts to your contract holders based on the tenancy they were granted. Now, the Welsh Government has released guidance on how to convert a tenancy into a occupation contract, and this is just a process here which they say that you need to undertake. So the first step is you should ask whether there are any existing terms which are incompatible with the fundamental terms of your model contract. If they are, you must remove the existing terms from the tenancy. After that, you must question whether there are any remaining terms which are incompatible with supplementary terms in the model contract. If so, you must remove the supplementary terms and replace them with the existing terms of your current tenancy. If there are any terms which are not incompatible, you do need to make sure you're still moving over those supplementary terms. And then finally, you must check whether there are any remaining terms of the tenancy which can remain as any additional terms. And as I've been saying, there will definitely be a lot of those. So make sure you are moving those over into your occupation contract. Okay. Next slide, please. Now, key changes. I'm now going to be looking at some of the key changes being introduced by the Act, just so you can look out for those and make sure that you're complying with the new regime. So firstly, grounds for possession. So the grounds that we see in Schedule 2 of the Housing Act right now, they will be completely removed and you'll be looking at a more simplified process. So the first ground for possession you will have is under Section 157 of the Act, and that's a breach of contract. So it's relatively simple, like your ground 12 that we use now. So is there any terms in the contract which tenant is breaching? If so, you seek possession on that basis. The next is estate management grounds. So they are set out in Section 160 of the Act, and they're also set out at the back of the the occupation contract. Examples of those are redevelopment grounds, so where the property is required for redevelopment. The other is special accommodation ground, so maybe the property has been adapted for somebody's needs and they don't have those needs. And then the other one is under occupation ground. So this is where you've got a reserved successor, they've succeeded to the property, but say the property is too large for them. And then the final one is other estate management reason. And under that, they've said that there must be a substantial reason for seeking possession on that basis. Now, for your estate management ground, you must ensure that there is a suitable alternative accommodation available, or that a property will be available at the time the order takes effect, so on possession. And for those grounds, the court must be satisfied that it is reasonable to grant your possession order. So just as well, these are for secure contracts, but this is what you will be dealing with ourselves. So on those for those two grounds for possession, as I say, they must be reasonableness. There is no mandatory ground for possession anymore. So no ground in relation to, ground 7A, serious antisocial behaviour, that's removed. And if you do meet those grounds, then you need to serve a notice, a 4-week notice. The notices are all different as well, so make sure you're on the government website and using the correct forms before you're looking to seek possession. And you must also ensure that proceedings are issued within 6 months of serving the notice, rather than 12 months, what we see now. So if you don't use it, you lose it. So I'd go ahead with that if you want to. Next slide, please. The other key change is enhanced succession rights. So under the Act, there will be a priority successor under Section 75, and this is succession to a spouse or a civil partner of the contract holder. And they must have occupied the property at the time of the contract holder's death as their only or principal home. They also must not be a priority. The contract holder must not have been a priority successor. The second succession right is to a reserved successor, and that is a family member. And to meet that criteria, there must not have been a priority successor, and the person must be able to meet the family member condition. And that is that they are a family member which is not a spouse or a civil partner. They must also have occupied the property at the time of the contract holder's death as their only or principal home, and they must meet the basic residence condition, which is that they must have lived at the property for 12 months before the contract holder's death. Next slide, please. And what we've seen being introduced as well, which we don't have now, is a reserved successor to a carer. And to meet that criteria, they must not be a priority successor. They must meet the care condition, which is that at any time in the period of 12 months, ending on the contract holder's death, they were a carer of the contract holder or a carer of the contract holder, a member of the contract holder's family. Okay. And a carer must be somebody who provides substantial care, and they must also not be doing that under a contract of employment. The other criteria is that they must have occupied the property at the time of the contract holder's death as their principal home, and they must meet the care residency condition, which is that they meet the basic residency condition, which is living at the property within a period of 12 months before the death, and that there was, at the time of the contract holder's death, there was no other property that they were entitled to reside in as their home. Okay, there is a lot to take in there. So I think, if you come across a succession, just make sure that you're, looking at the criteria, because, as I say, it's completely different. So we just need to make sure that it's being granted when it should be. If there is more than one person qualified to succeed, then the priority successor will succeed. If there is more than one priority successor or reserve successor, then the one person will be selected by agreement, or if they can't decide, the landlord can then select somebody. But that person does have a right to, or the other person has a right to appeal against a decision within 4 weeks. Next slide, please. The other key changes is to abandoned properties. So as we see now, usually when we've got an abandoned property, we serve our notice to quit and then we seek possession by going and issuing court proceedings, getting a possession order. Well, the Act introduces a new procedure, which is that a property can be taken back. You can repossess a property without issuing court proceedings. So again, they're looking to simplify the process here. But I think in practice, there might cause some difficulties, and I'll be going through those in a moment, because there is still a procedure to follow. The contract holder can come back. So yeah, we'll see how it works. But it might have been that it's better to just issue possession proceedings, get your possession order, and then we can move forward. But you can use this procedure. So the procedure is that the landlord must believe that the contract holder has abandoned the property. If so, they must then issue a 4-week notice, and then they must make inquiries. Now, in terms of inquiries, what you should be looking to do is trying to contact the contract holder with the contact details you have, contact their family members or friends, carry out visits to the property, speak with neighbours, and also speak with support services, so social services, for example, and just be sure that you're satisfied that that person has abandoned the property. Make sure you write those down as well, so you've got a trail of what actions you've taken. And then after that 4 weeks has expired, if that person hasn't returned, then you then serve a further notice, and from then you can take back possession of the property. If there is any lodger or stakeholder in the property, you can also serve a notice. You must also serve a notice on them, and there is also a right to re-enter the property at any time. That is to make the property safe, for example. Okay. Next slide, please. Now, the issue here is that the contract holder can challenge a repossession for up to 6 months after the date that the contract has ended. So they can come back, they can issue proceedings and potentially look to get back into that property. Now, there are 3 grounds they can challenge this on. So the first one is that the landlord has failed to give notice or make inquiries. The contract holder has not abandoned the property, or there is good reason for their failure to respond to inquiries. And then finally, when the landlord gave notice, they did not have reasonable grounds to satisfy that the contract holder had abandoned the property. And for this reason, I think it's, as I say, stress the importance of making sure you are noting down any inquiries you make to show the reasons why you were satisfied that they, had abandoned the property. If one or more of those grounds are made out, then the court can make a declaration that the notice is of no effect and that the contract continues, which means the contract holder can go back into the property, or they can also make any other order or an order for a suitable alternative accommodation, which I think would be the most sensible, because I'm sure, by the time if they came back, within 5-6 months and then they challenge repossession, it might be a year or so before, you get that determination, and you might have already relet the property. So it's more likely that suitable alternative accommodation would need to be given. Next slide, please. The other big change is in relation to repairs and fitness for human habitation. So these are set out in sections 92 and 91 of the Act. In terms of repairs, this is what we see already, so there's no change there, and just the same as section 11 of the Landlord and Tenant Act. But what's different here is the requirement to keep property fit for human habitation. Now, we've already seen this in England by the Homes and Fitness for Human Habitation Act, but this is a new requirement which obviously has been coming for a long time in Wales, with the Act being first put together in 2016, but it will bring the position up in line with England, albeit some slight amendments, slight changes. So what it will mean is that properties must be fit for human habitation at the occupation date and during the duration of the contract. It's going to apply to all secure, periodic standard and fixed term standard contracts for a term of less than 7 years. And there will also be an obligation to ensure that the common parts, other parts of the building, are fit for human habitation. Next slide, please. But what does fit for human habitation mean? Well, that is set out in regulation, specifically the Renting Homes Fitness for Human Habitation Wales Regulations 2022. And what they do is they set out 29 matters, including things like damp, heat, cold, crowding, space. So basically, a property does not need to be in disrepair for a determination of unfitness. It could be, for example, there is severe damp in a property, and that could be a result of lack of ventilation, something which would actually, for works to be carried out, would be an improvement, not a repair. So it extends landlords' obligations here. And I'm sure everybody's seen in the news this morning and last night the dreadful case of the little boy who sadly passed away due to damp in his property, a housing association property. So this issue is, really important. It's in the media, it's everywhere at the moment. So it might be that due to this fitness obligation being introduced, that there is going to be more work to be done there. Finally, here as well, as I said previously, there is a supplementary term in the model occupation contract that if a property is deemed unfit for human habitation, then no rent is payable. And as I said a little earlier, I think it's important here to be looking to slightly amend that clause just to make reference to if agreed by the landlord or if a determination has been made by the court. Obviously, that term needs to be agreed with the contract holder. Any amendment also needs to be in capital, so they'll see that this has been amended. So it'll be interesting to see whether there are any difficulties with looking to get that amended. Next slide, please. In relation to the fitness obligations, as well as the 29 matters, there are also other specific requirements set out, and these are firstly in relation to smoke alarms. So under the Act, every story of the dwelling must have a smoke alarm which is connected to an electricity supply. They must be present from the occupation date for any new contract after the 1st of December 2022. But for your converted contracts, you've got until the 1st of December 2023 to make sure that you're complying with that. The other obligation is in relation to carbon monoxide detectors. So these must be present in every room with a gas, oil or solid fuel burning appliance. They must be present from the occupation date or from the 1st of December 2022 for any current tenancy or license. So this one needs to be complied with now. So it's really important that you're looking to, ensuring compliance, carrying out checks, doing any works now before the implementation date of the 1st of December. And then finally, periodic inspection and testing. So that's your electricity certificate reports. So you need to make sure you're doing those, they say every 5 years. They must be made available to the contract holder within 14 days of occupation date, and then 7 days for any further inspection. And this applies to occupation contracts from the 1st of December 2022, so straight away for any new contract. However, for any converted contract, you've again got until the 1st of December 2023 to ensure compliance. So there's a bit of time there. Next slide, please. There are some limitations in relation to your requirements under the repairs and fitness. So firstly, you will only be liable where you were aware of the issues and the works were not carried out within a reasonable period of time. Okay, so if you are aware of any issues, if they are reported to you, just make sure that the works are carried out so that there isn't any argument there. The contract holder must also provide access for works. So if you are having any problems with access, that could be a defence to a claim. However, we would always suggest if there are issues with access, maybe possibly going down the injunction route to seek access to carry out any required works. The fitness for human habitation requirements will apply only to what the landlord can meet at a reasonable expense, having regard to the nature of the works, the value of the property and the landlord's financial position. And that is a really interesting one because that does not apply in England. In England, if the property is unfit, then the landlord must carry out those works. So here it's interesting that there is a requirement to do it, but only if it's at a reasonable expense. So if you are looking to do any work or that issue comes up, then just make sure again you've got a paper trail, you're carrying out a thorough analysis, investigation, and you've got justification for any works not being completed. There is also no obligation to carry out any required works where they are caused by any act or omission by the contract holder, maybe lack of care by the contract holder, or if there's a relevant cause, so like flood, things like that, or anything which the contract holder can remove from the dwelling. So there's no requirement to do works for those. Next slide, please. Action points. So finally, just for me to finish off, I just wanted to really give you some headlines. So firstly, occupation contracts and converted contracts, make sure that you've got those in order, you've got the additional terms in there, and you've carried out the correct conversion process. And then policies and procedures, obviously with a lot of things changing, so the fitness regulations, the succession, enhanced succession, your policies are likely to be needing to be amended, so make sure that that's done before the deadline. And then the next is start implementing a part 2 of the specific fitness requirements. That's your smoke alarms, your electrical certificates, things like that. Make sure you're looking to do those works now. And then finally, checking financing agreements. And for that, I'm going to move you over to Julian because he is the expert on finance, and he's going to be talking you through the issues that have come up there. Thank you very much.
Thanks, Vicky. Hi everyone, I'm Julian Barker. I head up the banking and capital markets team here at Devonshire's. We do work for a number of RSLs across Wales, so this is obviously a very live issue, and various clients have been asking questions around consents or potential consents required from their lenders. Could I have the next slide, please? So, as you'll be aware, I think pretty much all of you will have borrowed money from banks or via private placements from institutional investors, and you will obviously have inevitably entered into loan agreements or note purchase agreements if you've borrowed private placement monies. So there is, in every loan agreement and note purchase agreement, there are obviously corporate restrictions as to what you can and can't do with your business. One of those restrictions that will be in every loan agreement and or note purchase agreement will be around, there will be a restriction on making disposals. Now, that restriction on disposals will usually relate to the properties that will have been charged as security for that particular loan. And from a pure legal perspective, a disposal would capture the granting of these occupation contracts potentially. Now, obviously, each of you will have entered into different loan agreements, and we haven't reviewed every single disposal contract across the sector. But we have done a bit of a straw poll, had a look at a typical disposals clause in a loan agreement that has been drafted by Addleshaw Goddard or Pinsent Masons, who act for a number of the lenders who will have lent to you in Wales. I know there are other sort of lenders, for example, Principality, etc., who don't necessarily use Addleshaws and or Pinsent, but they are the two main law firms who have done the majority of the loans, I suspect. And so we've looked at their loan agreement, and the general position is that consent would be needed from your lenders. So we have been looking at this for a while. I think it didn't necessarily register on people's radars until sort of around the summertime that there is a potential issue here. So could I have the next slide, please? So obviously the starting point is you need to review all of your loan agreements to see whether you do need lender consent. As I say, the vast majority of the ones that we have looked at, they all do. You get to a position where lender consent is required. So therefore, if you haven't done so already, it's essential that you do make contact with your lenders as soon as possible. I think it has only really hit lenders' radar as well over the last sort of couple of months or so. So they have been a little bit slow to pick up on the point, but it is incumbent on you guys to contact your lenders and ask for consent. There was a suggestion around trying to get a blanket consent from all lenders in the sector who lend to RSLs, basically saying, yes, we consent to you entering into these occupation contracts. And we've had discussions with Addleshaws about this and said, could we potentially put in place a blanket consent? The issue is obviously there are the sort of the core terms, the model contract, but as Vicky's obviously alluded to, there are a number of variables that could change in each contract, and therefore Addleshaws have said, well, how can we kind of give a blanket consent when every contract could be slightly different? So that has not really been a viable option. So I think where we are now left is that you are going to have to go to your lenders. They will then be passing on to their lawyers to review the model that each of your contracts you're going to be entering into. Now, Addleshaws have looked at the model contract and said, yes, they are comfortable advising that it is fine from a lender perspective. Obviously, the key things for a lender is going to be, are these things going to have any adverse impact on the value of the properties, and or is it going to have an adverse impact on their ability to enforce their security should you ever get to a point where you've defaulted on your loans and they are looking to enforce that security. They have confirmed that the model form is okay from that perspective, What they can't say is, yes, the different variables that you will be adding in, whether that would have any adverse impact on either of those. So where we are getting to, I think, is that the RSLs I have been talking to have been sending through to their banks to then forward on to their lawyers, probably 3 or 4 of their contracts that they are going to be using. Obviously, there may be, I don't know exactly how many each of you will be entering into in terms of different formats. There will be elements of non-material differences between contracts, and therefore I think you'll be able to take a view that potentially you don't need to send every single contract, but as long as they are, you sort of send them the main 3 or 4, the format that you're going to be using. So there will be a little bit of discretion that needs to be exercised there. The key point is you should provide them with a markup against the model wording, the model contract, so that they can quickly just do a check through and say, yes, all these changes are fine, they have no adverse impact on the lender's security, and then obviously what you do then need is written approval from each of your lenders to say, yes, you can go ahead and put these occupation contracts in place. I don't think you need to really create sort of more work than you need to. I think an informal email from your lender saying, yes, we agree to the form of these contracts is sufficient. I think just some kind of email trail, you probably don't need a detailed formal consent letter. I just think something that you can point to, because I think there's going to be this initial flurry of activity to get the consents in place ready for the 1st of December. And then after that, I think the lenders really won't take the point that much. I think we need to just get ourselves over the 1st of December. And then as a matter of course, you'll be able to get consent from the lenders going forward. So that was really all I wanted to say, but it is a sort of a key issue to be working on. And I know the ones that I have been speaking to have been in discussions with their lenders. So I'll stop there. That was it from me. Perhaps hand back to Jackie to sort of deal with questions.
Thank you, Julian, and thank you to Victoria for that presentation. It was really insightful. We've got a few questions in the Q&A, so if anybody has got any last-minute questions, please pop them in. I'm going to kick off with one, if you don't mind. So what changes do you think are going to have the biggest impact?
So I think personally on my side, the housing management side, I think there will probably be a flurry of fitness claims. There could be, as we've seen in England, with Fitness for Human Habitation. From then, there was a lot of claims. There's a lot of solicitors, particularly in the north of England, issuing claims or letters for action in relation to all over England. It's not just limited to up north, but for issues with fitness for human habitation, so damp specifically. We've seen a lot of damp and mold cases, and actually it's also been highlighted by the Ombudsman. I'm not sure if people are familiar. In England, the Ombudsman published a report specifically dealing with damp and mold issues. So I think with this being introduced, fitness being introduced in Wales now, we're probably likely to see solicitors issuing those claims, because unfortunately a lot of them there is little merit possibly, or there's only a small amount of damages for the tenants themselves, but these solicitors are getting their costs, which is why they're issuing those claims. And I think until a fixed cost regime comes in for that, we're probably going to continue seeing them in England, and it's likely now, as I say, with that requirement coming in Wales, that we're likely to see that there too.
Right, thank you. So there's a few questions in the Q&As. So is it any of those that you'd like to sort of pick up and respond to?
Yeah. So within the key matters section of the written statements of converted contract, what is in terms of so there's a question about when a payment should be made in relation to a converted occupation contract. Now, the key method that it'll set out there, you'll be putting in there when payment is to be made, and it would usually be, payment on the first day of the contract, and then going forward, weekly, for example. So I think taking that from your tenancy and converting that over, although it converts on that day, the tenancy is already in place from a much earlier date. So I wouldn't be putting in the date of conversion. I'll be, saying that it's, to continue to be paid on a weekly or monthly basis.
Okay, thank you.
Yeah, there's a question here about breaches, whether you can combine those. And yeah, absolutely. So if there are any breaches, it's not limited to a certain one. If there is anything, then it's specifically a breach of contract. So you just be putting all of those in there. Yeah.
Okay. Right. And I've got another question. So what should RSLs be doing now? We're sort of getting closer. I know they've obviously done quite a lot of work already, but obviously we've got the sort of 1st December deadline. So in your view, what should they be doing now?
Yeah, so I think really important is making sure that those contracts are, put together, including all the details that you need to be in there. Firstly as well, policies and procedures, things like that, making sure that they're updated. I think, there's a lot of things that are going to be, going to be continued amending. So just making sure that they're already out in place for the 1st of December. Notices, things like that, making sure that you're familiar with those notices and the new forms which are on the government website. Also things like familiar with the CPR rules, they're changing as well, and I'm sure the reaction protocols will be amended too. So making sure you just keep up to date with those amendments.
Yeah, I think obviously on the banking side, as I say, checking the loan agreement to establish whether lender consent is needed, and if lender consent is needed, picking up the phone, seeking consent. They will say, we'll send us over the draft contracts. You then send those over with a markup against the model form, and then getting lender written approval in place. So that's the key point on the lender side.
Okay, thank you. There is a final question in there, I think, which is related to homeless accommodation. I don't know whether that's quite specific and needs a little bit more looking into before we can reply to that particular question.
Yeah, I'll have a little look at that and I'll message the person separately. But in terms of when certificates etc. need to be issued, for any new contract, they are in the regulation. You need to do that at the time. But the converted ones, those regulations will apply. As I say, the 2 of them from 2023, so you do have a bit of time. And one of them, I think it was the carbon monoxide, that would be from the 1st of December. So just make sure that's in place.
Okay, thank you. Well, as we haven't got any more questions, I think it's sort of time to wrap up. But thank you to Julian and Victoria for your presentations, and thank you for everyone who's attended. I hope it's been really helpful to you. So we'll obviously email out with the webinar, the link to it, and other information. So with all our contact details. So if you do have anything more for us, then please do contact us. And yes, have a good day. Cheers.
Thank you.
Thank you.